Here's a classic courtroom clash that still shapes how I think about property rights. Boomer v. Atlantic Cement Company, 1970. Picture this: a giant cement plant upstate, pumping out dust, smoke, vibrations. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Next door, homeowners can't open windows. Laundry gets coated in grit, walls rumbles. They sue for private nuisance. Basically, your operations unreasonably interfere with my use of my land. The usual remedy? Courts often issue an injunction. Stop the harm, shut it down. Simple, until you see the cost. Here's the problem. Shutting the plant would protect a few properties. It would also wipe out a massive investment. And lots of jobs. Damages alone might feel like a slap on the wrist. Pay the neighbors. Keep polluting. So what's fair? New York's highest court took a third path. It said, yes, this is a nuisance. The neighbors are right. But instead of an immediate injunction, the court ordered permanent damages. Atlantic Cement could keep operating if it paid the nearby owners for the ongoing harm, basically buying the right to continue the nuisance. If they didn't pay, then the injunction would kick in. That remedy reframed the dispute. The court balanced equities, private harm, broader economic impact, and landed on a cost-to-continue approach. If it's cheaper for the plant to fix the problem, it will. If not, it compensates the people bearing the cost. It's the seed of a big idea in law and economics. When rights collide, you can switch from "you can't do that" to "you can if you pay," creating incentives to reduce harm efficiently. But critics pushed back. One dissent called it a de facto condemnation, forcing homeowners to live with pollution because a company could afford to pay. Others worried it undermines property rights, public health, especially when harms are hard to price. So what's the remedy lesson here? Boomer doesn't say nuisance gets a free pass. It says courts can tailor remedies, where shutting everything down is wildly disproportionate. Permanent damages can compensate victims, while buying time for cleaner tech. In other cases, like toxic risks, injunctions still make sense. If you're a homeowner near an industrial site, Boomer means you might get paid for measurable harms, even if you don't win a shutdown. If you're a business, it's a warning. You can't ignore neighbors, because the meter might keep running. Problem: real, ongoing harm with high shutdown costs. Remedy: recognize the nuisance, then price it, unless the danger is so serious that only an injunction will do. 50+ years later, Boomer is still the go-to case for the messy middle between rights and reality. Thank you for watching. If you learned something new, please follow along for more. See you on the next case.